Good evening. Thanks for joining us tonight. A petition to ban former President Donald Trump from appearing on Minnesota's primary ballot has failed. This afternoon, the state Supreme Court rejected an effort to ban him from the ballot.
But the decision wasn't as definitive as Trump's attorneys had hoped. Morgan Wolf is here with more on the ruling and what comes next. Morgan?
Hi there, Randy and Julie. Yeah, the ruling comes just days after the Minnesota Supreme Court heard the oral arguments on this case. And while the court dismissed the attempt to get former President Trump off of the primary ballots, they left the door open for a case to be refiled for the general election if Trump wins the primary. In its 4-page order, the Minnesota Supreme Court rejected a lawsuit that sought to keep former President Trump's name off the ballot for next year's GOP primary.
They're not the right place at the correct time to hear the case.
But the ruling did not address the main question of the lawsuit, involving a constitutional provision that forbids those who, quote, engage in insurrection from holding office. The High Court instead cited state law that says parties can put whomever they want on a primary ballot, a ruling that could reverberate across the country.
I suspect that Colorado, Michigan, or other states that are going to confront this question are going to look to what Minnesota Supreme Court did.
The state Supreme Court says that they don't have the authority to keep a candidate off the primary ballot because those races are held by political parties, not the government.
They're private, and therefore the state court really has no ability to decide who may or may not be on those ballots.
And as U of M professor Tim Johnson points out,
our appellate courts in this country don't deal in hypothetical issues. And right now, Mr. Trump is only hypothetically going to be on the Minnesota ballot for the general election.
Trump's campaign team called the decision, quote, further validation of the Trump's campaign's consistent argument that the 14th Amendment ballot challenges are nothing more than strategic, unconstitutional attempts to interfere with the election. The court did not say that the argument is unconstitutional. They said the issue has to wait until after the primary, meaning that the case it could be refiled at a later date.
Could bring the lawsuit back up if, in fact, he is the GOP candidate. But for now, the case is essentially over.
The court will be issuing a longer opinion at a later date. In the meantime, Colorado's case, similar to this, is scheduled to hear closing arguments next week.